attorney Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the continuation in a LawCast series talking about cybersecurity. The SEC adopted Regulation Systems Compliance and Integrity, i.e. Regulation SCI, on November 3, 2015, to improve regulatory standards and processes related to technology in the securities business, including by financial services firms. Regulation SCI consists of 7 rules, Rule 1000 through 1007. The rules are as follows. Rule 1000 contains definitions, including defining an SCI entity. Rule 1001 contains the policies and procedures requirements for SCI entities for operational capability, the maintenance of fair and orderly markets, and systems compliance. Rule 1002 contains the obligations of SCI entities when there is an SCI-defined event, including corrective measures, SEC notification, and public notification. Rule 1003 contains requirements related to material changes and SCI reviews. Rule 1004 contains requirements related to business continuity and disaster testing. Rule 1005 contains record-keeping requirements. Rule 1006 contains requirements related to electronic filings and submissions. And Rule 1007 contains requirements for service bureaus. Regulation SCI broadly defines an SCI entity as an SCI self-regulatory organization, SCI alternative trading system, plan processor, or exempt clearing agency subject to ARP, and then contains drilled down definitions within the broad categories. Regulation SCI is meant to encompass and include any entity that is significant in the operation and maintenance of fair and orderly markets. SCI self-regulatory organizations include registered national securities associations, FINRA being the only one at this point, all national securities exchanges, registered clearing agencies including DTC, and the Municipal Securities Rulemaking Board, or MSRB. An SCI alternative trading system is defined by volume, broken down by NMS, which is the National Market System, and non-NMS stocks, and generally includes an alternative trading system with 1% or more of the NMS stock volume or 5% or more of non-NMS stock volume. Alternative trading systems, which trade only municipal securities or corporate debt securities, are excluded from the requirements. The OTC Markets is an SCI entity and has confirmed that it is in compliance with Regulation SCI. Interestingly, broker-dealers are not included as SCI entities. The SEC reasoned that all broker-dealers are subject to Rule 15C 3-5 and other FINRA rules which impose requirements related to the capacity, integrity, and security of the broker-dealer's systems and technology. However, the SEC did note that some broker-dealers are large enough that they could pose a real market risk if their systems were to break down or be infiltrated. The SEC may amend the rules in the future to include these firms. An SCI plan processor includes any self-regulatory organization or securities information processor acting as an exclusive processor in connection with the development, implementation, and/or operation of any facility contemplated by an effective national market system plan. There are currently 4 plan processors, including the CTA plan, CQS plan, NASDAQ UTP plan, and OPRA plan. An exempt clearing agency subject to ARP includes an entity that has received from the SEC an exemption from registration as a clearing agency under Section 17A of the Act, and whose exemption contains conditions that relate to the SEC's automation review policies, or any SEC regulation that supersedes or replaces that policy. There is currently only one entity that meets this definition. In addition, Regulation SCI breaks systems down into 3 categories, including SCI systems, critical SCI systems, and indirect SCI systems. meant to encompass systems and processes that are subject to heightened requirement, processes, and procedures. SCI systems include trading, clearance and settlement, order routing, market data, market regulation, and market surveillance. In particular, an SCI system is defined as all computer, network, electronic, technical, automated, or similar systems of or operated by or on behalf of an SCI entity with respect to securities, directly support trading, clearance and settlement, order routing, market data, market regulation, or market surveillance. A critical SCI system is an SCI system that directly supports clearance and settlement systems of clearing agencies, openings, reopenings, and closings on primary trading markets, trading halts, initial public offerings, the provision of consolidated market data, or exclusively listed securities. In addition, a critical SCI system is an SCI system that provides critical functionality to the market. An indirect SCI system is any system of or operated by or on behalf of an SCI entity if breached, would be reasonably likely to pose a security threat to SCI systems, and such systems only have to comply with the regulation SCI provisions related to security and intrusions. I'm securities attorney Laura Anthony, founding partner of Legal and Compliance and producer of Lawcast. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.